Shall we start? Can I kindly ask everybody to be seated? Dear panelists, participants, ladies and gentlemen, dear friends, I see a lot of friends and colleagues here among ourselves. I would like to welcome you on the panel on the role of international justice mechanisms in combating sexual violence. For those who don't know me, my name is Bekim Seydev. I'm professor at the Faculty of Law of the University of Pristina. I'm also a former judge of the Constitutional Court and former ambassador. I feel honored to have been asked to moderate this panel with very distinguished panelists. I feel as a privileged minority, actually, in such a distinguished panel with distinguished professionals, ladies and colleagues. Let me introduce briefly the panelists. Although their CV is very rich, I will have to be short, which has been very challenging for me. Our first speaker, the opening speech will be made by Madame Gresa Tsoka Nemoni, the President of the Constitutional Court of the Republic of Kosovo. Before becoming judge of the Constitutional Court, Madame Tsoka Nemoni worked as a senior legal advisor for the USA project and programs in Kosovo. She brings with her a very rich experience in legislative processes and the rule of law projects in Kosovo. To my left, the first panelist, Remziye Istrefi, is a judge of the Constitutional Court, professor at the Department of International Law of the Pristina University, Law Faculty of the University of Pristina, where we work together. Professor Istrefi has published books in academic journals. Some of them we published together. Also before, or in addition to serving as a professor and as a judge, Professor Istrefi has conducted several research and academic visits to various European and American universities, whereas she also was as a visiting lecturer at some of those universities. She established and chaired the Center for Transitional Justice at the Faculty of Law of the University of Pristina, and also was a national coordinator of the Erasmus program. Then second in line, we have Professor Dr. Ayla Shkrbic, Associate Professor of Public International Law. She works at the Dresden University of Technology in Germany, where she teaches several courses related mostly to international law, European law, and public law. Additionally, Professor Shkrbic teaches the course on sexual violence, gender, and war at the Bard College, Berlin. And prior to her current position, she served as Alexander von Humboldt Fellow at the Department of Law at Freie Universität in Berlin. Professor Shkrbic is also a certified lecturer for international law topics for the Civil Service Agency of Bosnia and Herzegovina. Welcome, Professor Shkrbic. The next panelist, Adriana Hanušić-Bećirović, is a human rights lawyer and active in this field for 15 years. She has been active since 2012 as a senior legal advisor at Trial International, an NGO which fights impunity for international crimes and represents victims of war crimes, primarily victims of conflict-related sexual violence. As of April 2024, she started working for Vital Voices as a conflict-related sexual violence documentation and transitional justice expert supporting those processes in Ukraine as well. She served on the UN Secretary General Civil Society Advisory Board on the issue of prevention of sexual exploitation and abuse. She has worked also as a legal expert for various national and international institutions and organizations, including the Parliamentary Assembly of Bosnia and Herzegovina, National Human Rights Ombudsman Institution of Bosnia, UNDP, OSCE, and so on. And last but not least, we have Natalie Smith, who leads the UK government's Preventing Sexual Violence in Conflict initiative, which was launched in 2012 and is backed by the fund of £60 million. This initiative is home of the UK's global leadership in preventing and responding to conflict-related sexual violence. Natalie is also deputy head of the UK Foreign Office Gender and Children in Conflict Department, which oversees UK efforts on women, peace and security, and children and armed conflict. A career diplomat and civil servant, Natalie has undertaken previous postings to the Democratic Republic of Congo, Tanzania, and she has worked on gender issues throughout her career. What an impressive panel. Before I pass the floor to Madame Graça Tsoka-Nemone, the President of the Constitutional Court, I need to make a couple of informations about the conduct of the panel. After the opening speech, I will make two general questions to the panelists, and then we'll open the floor for the audience, and obviously the panelists can also raise the issues which they think are important for the panel. Without further ado, I will pass the floor to the President of the Constitutional Court. I will kindly invite Madame Graça Tsoka-Nemone for the opening remarks on the topic.
Thank you, former colleague of the Constitutional Court of the Republic of Kosovo and Professor Sejtio. Dear Judge Istrefi, Judge of the Constitutional Court of the Republic of Kosovo. Dear Dr. Skrbic, Hanušić, and Smith, welcome to our country. Distinguished guests and participants. Let me begin by saying that I'm truly honored to be part of this two-day forum that brings together leaders, decision and policy makers, as well as civil society activists from all over the world to our republic, with one common purpose: to give more power, to give more voice to the global calls to end conflict-related sexual violence. In the last 2 days, we've had the opportunity to meet, exchange views, but also just listen to incredibly powerful voices fighting for gender equality, fighting against gender-based violence, and fighting to bring an end to one of the most horrific crimes, conflict-related sexual violence. Having this discussion in Kosovo 25 years after its liberation, it's not without emotion. Not without an impact on our own memory lane, on the memories of war and the experience of being a refugee, the experience of being deprived from human dignity. The stories we heard yesterday from Vasfia Krasniqi and Shurete Tahiri Sulejmani are not isolated. Their voices are multiplied by another 20,000 survivors of sexual violence in Kosovo. These extraordinary women displayed unparalleled resilience, heroism, and played pivotal roles in sustaining both the spirit and the survival of a whole nation. Their strength, determination, and sacrifice continue to inspire generations around a call, a global call, to collectively take all the necessary measures in order to end conflict-related sexual violence and the culture of silence and the fear of stigma, as well as, more importantly, to end the culture of impunity by strengthening the local and international mechanisms to address this heinous crime and hold the perpetrators accountable. Beyond geography, cultures, traditions, and faiths, rape and other forms of sexual violence have been used as the cheapest weapon, tactic of war. From the battlefields of the Balkans in the 90s, including Kosovo, to Rwanda, Sierra Leone, the Democratic Republic of Congo, Syria, and as we speak now, the wars in Ukraine and the Middle East. Unfortunately, however, while the use of sexual violence as a weapon of the war has been documented back to the Greek and Roman periods, the conflict-related sexual violence was recognized as a war crime through an internationally legally binding document only in 1998. And this says a lot. Despite meaningful efforts of the international community, and mostly the UN, in order to combat as well as prevent conflict-related sexual violence, the statistics continue to be striking, And as reported by the UN Secretary General in 2022, women and girls compose or account for 94% of the verified cases of conflict-related sexual violence, and 32% of the statistics are children. The numbers are shocking enough. However, the full horror of conflict is not, and sexual violence as a tool in conflict-related zones is not simply its prevalence, but it's also the devastating impact it has on the society, on the future of the entire generations. And this brings tremendous importance to this panel today, focusing on the role of international justice mechanisms in order to combat sexual violence. And in the limited time I have today, and respectful of the time that is available for my panelists, who are the real experts on the topic and who will bring the important value to the discussion of this panel that we have today, I will avoid walking through the normative framework on conflict-related sexual violence and the norms that the international law contains. I will, however, focus on 4 landmark cases of international tribunals, and that only superficially, cases that reflect the culmination of international mechanisms available, but also reflect the jurisprudence that will serve as the basis to strengthen these mechanisms, including international principles applicable as well as local legislation, in order to ensure both the prevention but also the accountability for these crimes. And let me begin by saying that the establishment of the ICTY marked a watershed moment, as most of us remember, in the history of international law on women in conflict. Its governing statute included the first explicit formulation of rape as a crime against humanity, and marked a significant international effort to make people aware of what has been one of the history's greatest silences, sexual violence in conflict. Since then, the ICTY, but not only, alongside with the International Criminal Tribunal in Rwanda and the Special Court in Sierra Leone, have been responsible for fundamental jurisprudence on conflict-related sexual violence as well as gender-based crimes. In fact, 1998 marks judgments of 2 international tribunals that have shifted the approach on how the conflict-related sexual violence is treated in the international fora. 4 cases, 2 different continents, established basic principles, including but not limited to principles that should have been established much earlier than 1998. That both men and women can be victims of rape, that a person convicted of rape does not have to be the physical perpetrator, that rape of a single victim can account and be prosecuted as a war crime, and that persons can be held criminally liable and responsible for sex crime as individuals and superiors. Moreover, this case law qualified rape as an instrument of genocide. The first case, namely the Akayesu judgment, derives from the story of a 6-year-old girl. A girl from Rwanda whose history turned the pages of history itself. A girl whose story, whose pain, led to the first judgment of an international tribunal qualifying rape as an instrument of genocide. And as you may recall, despite the vast documentation and evidence presented by human rights and women organizations that concerning the war crimes committed in Rwanda, the initial indictment against Akayesu did not include the account of sexual violence. It happened, in fact, in a moment that was a turning moment in the events in that trial, the spontaneous appearance of a witness who discussed and told the story of her 6-year-old girl being raped by gang rape. And this is when a domino effect was triggered and when multiple witnesses came to the stand to speak about their experiences as victims or as witnesses. And the single women judge at the bench at that time asked the prosecution to look into this issue further, because it appeared that this was not an isolated but rather a systematic weapon of war used against girls and women in Rwanda. Ultimately, Akayesu was sentenced to life imprisonment. Justice was delivered, but not only. This is the first case that established the practice based on which rape is genocide. Now, as we go on, in parallel with Rwanda, unfortunately, similar scenes were happening in the territory of former Yugoslavia, primarily in Bosnia and later Kosovo, where rape and all forms of sexual violence were used as weapons to systematically instill fear, humiliation, and powerlessness. And there is a trilogy of cases, 3 primary cases, Celebici, Furungia, and Kuranac, which convicted several perpetrators of rape, finding rape and other sexual violence against women to constitute torture and therefore grave breach of Geneva Conventions and international law. The first case, and just briefly, Celebici case, constitutes a leading superior responsibility case decided by ECTY. The second case, Furungia judgment, qualified rape as a crime of torture and outrages upon personal dignity, both categorized as violations of laws and customs of war. Finally, Kunarac further solidified this case law, strengthened the principles, but more importantly also is the first international trial in history which qualifies rape also in the category of sexual slavery. More importantly, needless to say, because experts are here, the court found that the Serb soldiers actually identified specifically the victims for being women and for being Muslim, which also constituted discrimination, which certainly is an explicitly prohibited purpose of torture. Now, while the international law and international justice mechanisms, as briefly outlined, have on paper given conflict-related sexual violence in all its forms a recognition amongst the most serious crimes, and while the United Nations, the Security Council, and UN-led agencies continue to make all efforts to prevent and effectively prosecute and punish these crimes, in fact, conflict-related sexual violence remains largely unpunished, perpetrating impunity. And this brings me back to the wounds of the Kosovo history, the wounds of the Kosovo people, and not only in terms of memory, suffering, and pain, but also as an argument that conflict-related sexual violence affects entire generations, affects the future of a nation. Last weekend, we marked the Memorial Day on April 14th, the Memorial Day for Survivors of Sexual Violence. We have the most beautiful monument in our capital city, the Heroines, which serves as a reminder of the suffering and pain, but also the heroism and not only the commitment for the future, the commitment for the Kosovo people to participate in the global call in order to prevent this atrocity from the future. We must replace impunity with unity. We must replace the stigma with solidarity, and we must replace the theoretical calls with action. With action so that we prevent seeing those scenes in the future. And unfortunately, the scenes of the 90s are not only now part of history. We are witnessing similar events right now in Ukraine and the Middle East. And as we speak, sexual violence is being used as a tool, as a mechanism of war, and this needs to call to all our consciousness in order to finally act and not only punish, but also prevent this horrific crime. And with this, I will let you listen to the real experts, but it was a real pleasure to be part of this panel and share the floor with this wonderful team of experts. Thank you for your attention.
Thank you very much, Ms. Tsaka Nemoni, the President of the Constitutional Court. Before opening up the discussion, Ms. Tsaka Nemoni mentioned, or at least emphasized, two important messages or conclusions from her speech. The role of international justice mechanisms in ending one of the most terrible silences of history, which is conflict-related sexual violence. And also the fact that conflict-related sexual violence remain still largely unpunished. And the impunity is the order of the day, and at least us who come from this region are pretty much aware about this terrible fact. Now, I will open up the discussion with a question, a general question, and obviously would like to hear from the perspective of the distinguished panelists, because as we saw from the CV of each of the panelists, they bring very rich experience from various perspectives, be it a judicial perspective, a civil society perspective, institutional perspective, or the policy-making perspective. And my general question is about your view on the role and the challenges of the international justice mechanisms in combating the the conflict-related sexual violence. So I'd like to hear your perspective, your experiences as professionals in dealing with this field in various domains about the role, as I said, and also the challenges that we all know, and it has been discussed at length in this forum as well, we still face in combating the conflict-related sexual violence and in bringing to the justice the perpetrators. Perhaps I will start from Judge Professor Remzieh Istrefi. Yes.
Well, thank you. Thank you very much, dear colleague, Professor Bekim. Prior to answering the very relevant question, I would like to avail this opportunity, because having all you here, I really want to at first greet my President of the Constitutional Court, indeed you, yourself as a chair, my dear panelists, old friends, new ones, but specifically I want to greet my students. My students who are sitting on the third row here, and I just want to introduce you to them, because this is the first generation of the students of the University of Pristina who are attending the first MA program on transitional justice, international criminal law, and human rights. And we are very proud of this program because we are having international students as well. So I invite you to promote this program and invite other students who would like to come to Kosovo and study this very specific field. So again, thank you for being here. I think that related to your question, Professor Bekim, I consider that there is no better forum than this one, our forum today, to talk about the challenges related to prosecuting conflict-related sexual violence. I think that we need an honest dialogue. Actually, we need to sit and speak openly. What are the main misconceptions when it comes to prosecuting conflict-related sexual violence? As you heard from my respected president, the turning point related to prosecuting conflict-related sexual violence is quite new, I would say, because we are speaking about ICTY coming to a point where we declare or we codify the conflict-related sexual violence even to a level of genocide. But as we all know, the conflict-related sexual violence is centuries old. So now or I think we are even too late to open the honest dialogue. What are the main problems and issues that we have come so far without seeing really what kind of a crime is it? And again, I go back. It is a very good forum today to talk, and it is a very good place, actually, because we are speaking, and we are in Kosovo. Kosovo's latest war was characterized with thousands of people who have been killed. Still, many more missing. But above all, we are speaking about around 20,000 victims of conflict-related sexual violence. So that is why the question that Professor Bekim posed to us, but also to all of us who are sitting here, is of the highest relevance. Based on my research and the work that I have done as a university professor and as a researcher, I have grouped some of the themes which have had an impact when it comes to prosecuting conflict-related sexual violence, but at the same time that can serve us as a lessons learned for Kosovo judicial system and prosecutorial system, because as you all know, now prosecuting conflict-related sexual violence is in the hands of the Kosovo system. Saying this, I am referring to the previous periods when we had United Nations mission in Kosovo who had the responsibility to prosecute conflict-related sexual violence. Later on, EU mission, but now, since 2018, the prosecution of conflict-related sexual violence is in the hands of the domestic institutions. So in that sense, I think that all of us, we should turn and learn from other experiences in order to assist in prosecuting this very violent crime. So I have gathered some issues that I want to share with you. I trust and I know that there are more misconceptions when it comes to prosecuting conflict-related sexual violence. However, I would like to point out the following. At first, from the experience, international one, but also domestic one, the notion that rape is more a sexual matter involving damage to a woman's honor than a violent crime. So this is a notion that has been evidenced at ICTY, ICTR, but also at the domestic level. Usually, conflict-related sexual violence is misconcepted that this has to do with the honor of the person who has been a victim. If the institutions and society and whoever is involved in this process continue to use this misconception, I trust that we are going to have issues. And why I'm saying is based on the following arguments. If we do so, this can lead to discounting the seriousness of the sexual violence, assuming it as necessary as only an act that was done as an opportunistic position of the perpetrator, which is not the case, because usually conflict-related sexual violence happens not as an opportunistic way. We have evidence that this is happening in different ways. So in that sense, I think that in order to cut the pattern of the violent conflict, we need to switch and to see the conflict-related sexual violence as a violent crime. Why I'm saying this? I think the misconception that rape is more a matter of honor than a violent act also affects the fact that survivors themselves continue to feel as being ashamed of what it has happened to them. And this should not be the case. We should unpack the title, the event, on the basis that it is a violent crime, and that shame has nothing to do with the honor of the person. We have to see it as a violent crime if we want to give the exact weight of what it has happened. So in that sense, I must say that this misconception also has been reflected in the international law, in the dispositions that have codified the issue of conflict-related sexual violence, in the sense that conflict-related sexual violence cases have been somehow shifted not to be serious enough, because usually the international tribunals, but also domestic courts, have concentrated on the highest or on the gravest acts, which are usually related to murder, mass crimes, and so on. And in that way, Also, adding to the fact that international tribunals, but also domestic courts, have also other operational issues that affect them, it has led them, that conflict-related sexual violence, to become in another dimension. So in that sense, I think we all have a role to remove this misconception. And I say that we have a role also, we as a university, because we have to educate new lawyers and new generations that this is a violent act, and of course, the way how it is used is something different, but we need to remove the misconception that this has to do with the honor of a woman. I will come back again to this element if we have time, but I really want to go quickly to all the themes that I have grouped so that they serve as lessons learned. The other misconception related to conflict-related sexual violence is that conflict-related sexual violence is not so serious as other acts that are taking place during the conflict. For longer periods of times, and I think we have witnessed that also in Kosovo, but also in other post-conflict situations, the attention has been given usually to, as I mentioned, murders, mass crimes, and mass atrocities. That is all okay, but we need to learn simultaneously also to address the issue of conflict-related sexual violence. What we have seen in ICTY, for instance, at least for the beginning of their work, we have seen that the court has been concentrated more on those conflict-related sexual violence which have been related to the highest level. And when it happened in mass, so meaning many individuals have been raped or so on, but somehow all that is okay, but we have missed individual cases because conflict-related sexual violence happened also during the expulsion. So let's say a group of military forces entered into a village, they killed someone, in a house they raped one woman, and then they continued to do the looting and economic destruction, and somehow this rape was left out of the discussion. So I think that also this issue needs to be taken into consideration. The other misconception is that sexual violence is personally motivated or is opportunistic by those who are committing it. If we continue with this misconception, then there is a risk that we view that rape and other similar acts are purely sexual matters, which is not the case. So in this sense, we have to be very careful where we are and how we are using this misconception, because we need to move from the direct perpetrator case. We need to see how the entire situation has taken place. In other words, we need to learn how to contextualize the entire scene of the crime, so that we remove the attention from the issue that is related to personally motivated or opportunistic. So I was there, so I saw a woman alone, and then I used the opportunity, and this is how it goes. These were the claims of most of the perpetrators at ICTY. So, and I think this is a risk. If we concentrate in this modality, then we are losing a lot from the crime that has taken place. The other misconception, and then I think I'm going to release the floor, is that conflict-related sexual violence can only be prosecuted if it is systematic, widespread, and committed pursuant to orders. As I mentioned, this is all okay. Usually, international tribunals, they concentrate on the highest level of the perpetrators, meaning even including those who have authorized the acts. But if we do so, then we are going to miss a lot what actually happened on the ground, because the highest number of the conflict-related sexual violence that took place in Kosovo, according to the writings of civil society and journalists like my colleague that is sitting over there, they show us that actually in some places the rape was not systematic. It was here and there, but in some cases for sure it was systematic as well. So in that sense, I think the institutions should pay attention equally to conflict-related sexual violence that has taken place as widespread, but also to individual cases. And the final misconception that I want to share with you is the fact that concerning the sexual violence that is taking place or has taken place against men. So this is one issue that we are missing a lot, actually, and not only at the domestic level, but internationally as well. So what I'm trying to say here is that while most of the misconceptions related to the conflict-related sexual violence towards females, at least we have recognized some of the misconceptions. But when it comes to males, I think there we are missing a lot, because we have not paid attention to the conflict-related sexual violence towards men, or very little, I would say, and also we have to take into consideration their needs and the way how they are going to present. So just 2 words, the way forward, what we should do as, in this case, as Kosovo, what the Kosovo prosecutorial and judicial system should do. At first, we should open an open dialogue with judges, prosecutors, civil society, academia. We should sit together and see what are the major problems. Of course, international law and domestic law are quite codified, and we can say that we have a fairly good established legal framework. However, when it comes to putting it in practice, I'm afraid that we need some more information about it. And I think we can learn, because international tribunals and some domestic courts have advanced to that level, that they have established advisory boards for the judicial and prosecutorial system, advisory boards that are comprised by judges, prosecutors, professors, students, civil society, psychologists, sociologues, and so on, so that they sit and they discuss in depth the nature of the crime and the way how it should be contextualized in order to have better results. So I will stop here my intervention. I hope I was okay with timing. Thank you very much for this opportunity, and I really look forward to interventions and questions and so on. Thank you.
Thank you very much. Thank you very much, Judge and Professor Remziye. Thank you for raising very important points, and also thank you for being very precise in timing in your presentation. Perhaps it is a skill from the lecturing, because we have to finish our lecturing in a certain time limits. You emphasized very important points. I will just in a couple of seconds reiterate them, starting from with what you started and concluded your speech. We need honest dialogue about misconceptions on this conflict-related sexual violence, whereby in Kosovo, as we know, and I'm pretty sure that these days you have had the chance to hear it constantly, there are around 20,000 victims in Kosovo, and that now the prosecution of these crimes is under the jurisdiction of the institutions, justice institutions of the Republic of Kosovo. With regards to the misconceptions, you emphasized the fact that the rape has not to be seen as related to the honor, but as a violent crime, because as you emphasized, if it is related or if it is conceived as a crime that dishonors, then there are other consequences related to it, such as the silence, the stigma, and so on. And also you emphasized the fact, which is crucial from at least from the judicial perspective, that in terms of the gravity, rape is not considered at the same level with the other crimes as a means to commit other crimes such as mass murders and so on. Also, another misconception that you emphasized is the fact that sexual violence is interpreted or at least perceived as a personally motivated crime. And then also the crime that has to be or is prosecuted only if it is massive and systematic, not as a crime that also, in order to be prosecuted, does not need necessarily to have that dimension in terms of persistence and massivity. And finally, the conflict-related sexual violence against women has overshadowed the fact that, although to a much smaller number, but still that numbers are not always important, the male were also a victim of this crime. So thank you very much for raising this important point, and I'm also looking forward to have questions. But first, before we go to the panel, I would like to pass the floor to our second panelist, Professor Dr. Ayla Shkrbic, to give her perspective on my question, my general question, but also any other issue or question related to the topic.
Good
Welcome.
afternoon, everyone. Professor Seydiu, thank you for your kind introduction, and thank you so much to everyone who made this event possible. It is really an honor to be among so many people who have made significant contributions to the realm of international justice mechanisms, which we are discussing today. Coming from Bosnia and Herzegovina, I've had the opportunity to witness various atrocities committed during the 90s and the subsequent development in prosecuting these crimes. I've devoted my professional life to researching and in a way combating these crimes, especially conflict-related sexual violence. And through my work, I've come to realize that only sheer coincidence spared me from experiencing such atrocities firsthand. And therefore, this topic is very close to my heart and very important to me. So what are my thoughts regarding international justice mechanisms? Firstly, I believe this term should encompass more than just formal justice mechanisms, as is often assumed. I think we should have a broader understanding of justice. I think we should encompass here also transitional and traditional justice mechanisms. If we want prevention and deterrence to be successful, I think we need to think beyond trials. Why? Because in my work so far, I've never encountered a single survivor who said that the only thing they need is for the perpetrator to be prosecuted. Most of them firstly express a wish for the world to acknowledge what happened to them and to acknowledge that what happened to them was wrong. This does not mean that we don't need trials at all. The trials are in a way a symbolic acknowledgement that what happened to the victims was wrong and that it should not have happened. But I think that the trials should be just one part of a broader set of activities and responses. After all, no court nor the collective effort of all courts are able to prosecute every perpetrator of conflict-related sexual violence. And moreover, trials alone cannot guarantee justice without complementary measures. I'll give you one example. So in Bosnia and Herzegovina, but also in other post-Yugoslav countries, there is limited public support for the prosecution of the members of the ethnic majority. So consequently, we have situations where war criminals who belong to the ethnic majority are publicly portrayed as heroes and celebrated by some politicians and also in the media, regardless of the eventually court-imposed sanctions. This, in turn, is detrimental to survivors, and it perpetuates the stigma attached to them and their communities. At the same time, this is directly linked to the society's trust in the jurisdiction and trials, and it is directly linked to the willingness of the victims and survivors to come forward and share their stories. So if we want to improve prosecutions of conflict-related sexual violence, and if we want to encourage more survivors to come forward, we need to address these issues as well. The second thing I want to share today is my understanding of the role of international justice mechanisms. I firmly believe that the primary function of international justice mechanisms is to be complementary to the domestic ones. Once again, I think that Bosnia and Herzegovina serves as a prime example. So if you look at the war crimes trials across post-Yugoslav countries, it's undeniable that the performance of the Bosnian judiciary was the most successful one, both in terms of quantity and quality, and including when it comes to conflict-related sexual violence. In fact, this country is considered as the best example of the successful domestic prosecutions of conflict-related sexual violence worldwide. And for the past 2 years, I've been comparing cases of conflict-related sexual violence in 3 post-Yugoslav states, so Bosnia and Herzegovina, Croatia, and Serbia, and the differences are indeed striking. I examined a 10-year period, so from the 2010 to 2020, and the highest courts in, as I said, Bosnia and Herzegovina, Croatia, and Serbia. And I found that in Bosnia and Herzegovina, during this 10-year period, a total of 62 cases that involved conflict-related sexual violence were resolved with final verdicts during this period. In Serbia, there were only 7, in Croatia, only 4. All of these numbers are depressing and devastating, especially considering the pervasive nature of sexual violence committed in the former Yugoslavia during the 90s, which was so shocking that it led to a paradigm shift in our understanding of sexual violence, and it led to the WPS agenda as we know it today. But still, Bosnia stands out positively among all of these countries, and as I said, both in terms of quantity and quality, and I'll give you a couple of examples. So when Bosnian laws were not in line with international laws, with international standards and norms, Bosnian prosecutors and judges sometimes used the ICTY jurisprudence and procedural standards. This was the case, for example, with the definitions of sexual violence offenses, which up until 2015 in Bosnia and Herzegovina required the force or the threat of the use of force in order for sexual violence to exist. However, the judges and the prosecutors overcome this issue, overcome this shortcoming by using the ICTY definitions and jurisprudence. Another example is the practice of the judges of the Court of Bosnia and Herzegovina not requiring corroboration of witness statements in the cases involving conflict-related sexual violence, even though the Bosnian Criminal Code of Procedure does not involve such a provision. However, the judges once again use the ICTY and international standards and norms in these cases. So why were Bosnian prosecutors and judges more successful than their neighbors? Among all post-Yugoslav states, Bosnia and Herzegovina has had different relations with the international community and received the most extensive support from the international community in rebuilding the rule of law after the wars. So Bosnia is a living proof that post-conflict states, which are impoverished both in terms of people and finances, can be successful to bring war criminals to justice if they are given an appropriate support from the international community. But what I especially want to highlight here is that when I say this support, I don't mean only in support in finances, but also in expertise. So, for example, in Bosnia and Herzegovina, up until 2013, in the state bodies, we also have the so-called international personnel. So in the Court of Bosnia and Herzegovina and in the Prosecutor's Office of Bosnia and Herzegovina, we had also foreign prosecutors and judges. And I believe that they they facilitated easier introduction of international standards and norms within domestic legal framework. I believe that they played a significant role in this success and these achievements. The Bosnian example shows that if you have well-trained experts who are up to the tasks set before them, a good solution can be found even when the laws are not in line with international norms. So to conclude, my main message is that we need to use all available tools in the box for a successful fight against conflict-related sexual violence, and that complementarity is crucial. So it's key when it comes to formal and informal justice mechanisms, and it's key when it comes to international and domestic justice mechanisms. And the picture is not black and white when it comes to international and domestic justice mechanisms. International courts have provided a wealth of jurisprudence that defines sexual offenses and confirms their status under customary international law. They helped mass rape graduate from an inevitable byproduct of war to a threat to international peace and security. So at times, the necessary expertise resides within the international mechanisms and international system, and in such cases, it must be borrowed to the domestic legal systems. How? By utilizing standards, norms, technical support, training, expertise, funding. However, in some other instances, the expertise is found within the domestic system. And therefore, both worlds need to work together and influence each other if we are to effectively process sexual violence. Both domestic and international mechanisms are essential for addressing conflict-related sexual violence. And success in this fight relies on their cooperation and complementarity. And I'll stop here. Thank you.
Thank you very much. Thank you very much, Professor Skrbic, for bringing your experience as an expert, but also as a citizen of Bosnia and Herzegovina, and by emphasizing very important points which are very relevant to each case, including to our country, starting from the fact that, as you said in the very beginning, which is very important, that justice in these cases of the conflict-related sexual violence should acquire more broader meaning than prosecuting individuals. Obviously, that's a crucial, but not necessary. And also, you brought important an important issue which is also quite relevant for our experience in Kosovo, as we also had similar experience when it comes to the way that the justice system works with international and domestic judges and the justice structures, at least we used to have for a couple of years. And you emphasized the role of the well-trained experts, in terms of judiciary, so justice experts, the importance of having international support, not only financial but also in terms of the professional expertise. And as the president of the Constitutional Court is here, Judge Ramzi and myself, we have also worked with international judges for a couple of years, and that's also has been very important. Obviously in the Constitutional Court, not in the criminal panels, but still we have seen the importance of having experienced, a well-trained expert. And also, thank you for raising the issue of this dichotomy between the national and international judges and the court system, and which each can give to the other, and which are supplementary to each other. Now I will move to the third panelist, Mr. Adriana Hanušić-Bećirović. As I said, with a vast expertise, legal expertise on human rights, I will pass the floor to Ms. Hanušić-Bećirović to give her remarks or answers on the question and the issues that we are discussing. The floor is yours.
Thank you, Professor Beckham. Good afternoon, everybody. It's a great honor to be participating at this forum and to speak at this forum and to be part of this great panel. It's a great pleasure to be listening to you throughout those 2 days, participants or speakers, and to talk about those very important topics. Please allow me to start with a very personal reflection on the importance of international justice mechanisms. It's 1992, springtime. I'm a 7-year-old girl living in Bijeljina, in the northeastern part of Bosnia and Herzegovina, when the war starts, and it starts in this city. And it certainly did not start by the neighbor of our home shooting at us, or my father shooting at him. But it started when paramilitary troops from across the Drina River entered our city. After 2 years of constant fear, threats, discrimination, and loss of basic rights and dignity, we finally succeeded in fleeing the city. In 2007, it's summertime, 2 law students are drinking coffee in Belgrade, discussing the outcome of the case known as Bosnia and Herzegovina against Serbia before the International Court of Justice, which failed to establish Serbia's responsibility for the commission of genocide in Srebrenica. We are discussing the role of Serbia in the war in Bosnia and Herzegovina, and my friend firmly believes what he has been reading in school books and what he read in the judgment. And his opinion is that Serbia bears no responsibility. It was an internal war. And although I have my truth, I have my memories, my lived experience, I feel helpless because it just doesn't matter. 2023, springtime again. Last year, I'm in Vienna preparing my speech for an OSCE conference on justice for victims of torture focused on the Ukraine, when I find out that Stanisic and Simatovic, Serbia's highest-ranking security officials, have been found guilty of joint criminal enterprise for crimes having been committed in 1992 by Serbian forces in Bosnia and Herzegovina, including my hometown, Bijeljina. Would today the conversation between those two law students, be different after such a ruling? Absolutely, it would. Did I get emotional while reading this text, this lengthy text with the established truth which my family lived in 1992? Yes, I certainly did. Did it bring a feeling of closure and satisfaction to me? Yes. Although it is about remote common responsibility for what happened. And this is the importance of international justice mechanisms. I have been speaking for 14 years, last 14 years, with survivors of conflict-related sexual violence, from Vlasenica to Foča, to Bratunac, to Zvornik and the surrounding villages on the long left bank of the Drina River. And I've been listening to their personal stories unfolding in parallel on very similar dates, with patterns overlapping, with accents from neighboring countries of the perpetrators being mentioned. And every time I could not help but be anew shocked by the extent to which this seemed as something cold-heartedly planned, well coordinated, and perpetrated in a systematic manner. We have heard about the incredibly courageous women from Bosnia and Herzegovina, primarily Foča, the Ferunđija and Kunarac case, who witnessed, who testified before the ICY right after the war ended. It takes courage today. You know how much courage it takes. Imagine just the courage it took back then. And I wish to pay tribute to those women, and also to feminists and lawyers from Bosnia, but also from abroad, those who have been working at the ICY and the ICTR, who helped advance those norms and set those standards we have been hearing about today. But there are also so many of those victims who will never have this kind of opportunity, as we also heard today, because the perpetrators cannot be identified, or they died, or simply because a victim does not wish to testify, which is also a legitimate personal choice that we have to respect. And in such case, proving common responsibility, which mainly happens and happened before international justice mechanisms, may be the only way they will be able to experience this satisfaction of establishing the truth, what happened to them or their community. We have also heard about a very important role, and which I also mentioned, and this is standard setting. I cannot emphasize enough how important it was for us local actors who have been fighting on the domestic ground to apply those standards, to fight against impunity, to respect victims' rights. And we have been relying on those judicial mechanisms, but also the recommendations of quasi-judicial bodies, the UN treaty bodies, the UN special procedures, and their recommendations. And in Bosnia and Herzegovina, it started, like Ayla told, with the presence of international judges and prosecutors who distilled this, channeled this knowledge from the international level, and then through extensive training supported very much by the PSVI initiative, and then also through alignment of domestic laws and rules with international standards. This is immensely important because in the end, the vast majority of direct perpetrators will precisely be prosecuted at the ground, at the domestic level. So it was crucial to ensure that it is done the right way. And the right way means the highest possible extent of conviction rates, the highest standards to be respected when it comes to the protection of those victims and witnesses participating in proceedings, and also trying to achieve as much as possible a survivor-centered approach. And I can share a couple of lessons learned with regard to this survivor-centered approach from our work with victims, various victims. First of all, the biggest challenge we had, as was mentioned before, is to make prosecutors' offices prioritize, as Professor Remziye mentioned, the prosecution of CRSV crimes, because they tend to be regarded as lesser crimes. That's the reality. You can have the best laws, the best training, but if a prosecutor is not really ready to dedicate him or herself to prosecuting those crimes, then you have a problem. So through advocacy efforts, we triggered in 2014 an first official announcement of the prosecutor's office that they are willing to prioritize the prosecution of CRSV crimes. And then after it was prioritized, after it was intensified, we began through the conversations we had with our victims to observe gaps which needed to be addressed in order to make this experience of participating in criminal proceedings be an empowering one and not a re-traumatizing one. So we figured that punishment in itself is not enough. We realized that we have to strive to set systemic conditions, making room for this experience to bring them what they initially expect. And what do they expect? They expect that they go into this courtroom and that the whole proceedings will be there because of them and for them. And this is not what they are experiencing. In order to ensure justice, it is first of all important that the sentencing policy for CRSV crimes is adequate, that the sentence is proportional to the severity of the crimes. But of course, if you do not, as Professor Remzieh said, if you do not regard it as a very important crime, then it will be reflected also in the sentencing policy. So we began tackling this through awareness raising and policy research and capacity building, etc. And then we also started to combat stigmatization in courtrooms. Professor Remzieh also mentioned this. Stigmatizing attitudes, remarks, and actions which were based on rape myths, centered on shame, like it was mentioned, promiscuity, consent, gender-based stereotypes which still pervade criminal proceedings in Bosnia and Herzegovina and many other countries. But most importantly, for a true sense of justice and for making this a transformative experience, we realized that we must try to put the victim at the center of the proceeding by making them not feel as a passive, simple evidence tool, but to put them in the rights of an active right, in the shoes of an active right seeker. So how we did this is, in order for this to happen, we organized a creative advocacy strategy, which led in 2015 to a major breakthrough in the Western Balkans, when for the first time in history, a war crimes victim has been awarded compensation in parallel to a conviction of a perpetrator. And since then, it became common practice in Bosnia and Herzegovina. We have around 20 cases with such an award of compensation. As one survivor put it, once she found out about this outcome, she told that it's important for me to be able to tell my daughter, demonstrate her for this example, that when somebody does something bad, he has to pay for it. After that, we ensured through legislative amendments the obligation of the state to provide legal representation to the victim, because imagine you're coming in as a victim in the courtroom and you're seeing that the state is funding the defense lawyers of the perpetrators of those heinous crimes, and you are there on your own, alone. So this was also a very important element in ensuring this survivor-centered approach. And slowly you could really feel a change in atmosphere amongst the victims we supported under such new circumstances. They felt during the proceedings that there was this increased attention of various actors involved in providing support to them, prosecutors and judges and legal aid providers, etc. And in the end, the outcome meant a lot to victims. And one crucial lesson we learned is also something which Ayla mentioned, is the perception of justice as a highly individual question which varies from survivor to survivor and encompasses many different elements. Sometimes it can also change during the lifetime of a survivor, depending on their needs at a given point in time. For instance, one survivor might prioritize prosecution over compensation, or vice versa. Another one, as I mentioned, might not be willing at all to participate in criminal proceedings because she doesn't have the strength anymore to testify over and over again, which is also a choice we have to respect. It's their personal choice to make. And finally, we also have to bear in mind that, as Ayla also mentioned, we must not perceive justice in very narrow terms through this criminal justice lens, the lens of punishing the perpetrators. Because most of the time, for justice to be satisfied, victims also need wider recognition within their communities of what happened and condemnation thereof. It is important to provide for memorialization efforts. And it is also important for victims that once established judicial facts are not being denied, and that war criminals are not being glorified. which happens unfortunately all too often in Bosnia and Herzegovina and in our region. For instance, those survivors, those courageous women that we are mentioning throughout those 2 days, is it enough for them, the Kunarac and Frođija case? Can it be enough? Let me tell you about the situation on the ground. Not to mention the morals dedicated to war criminals like Ratko Mladic that they are seeing every day in their communities. Let's take the example of the sports hall where they have been collectively raped. A couple of years ago, there was this reconstruction of this infamous partisan hall in Foča with the support of the European Union. And it was reconstructed without their support, without having been conditioned, at least with the provision even of a small memorialization effort, at least a tiny little plaque stating what happened there. That's what we are talking about here. So is it enough criminal justice? Of course it's not. You have to ensure that the community you're coming from is accepting what happened and that the international community is also supporting those efforts because they have space if they wish to prioritize this to ensure that at least those tiny symbolic steps are being taken. So if we consider some basic definition of justice that individuals receive what they deserve, it becomes evident that many elements, criminal justice and effective outreach about the outcomes of this justice, and reparation measures, and acknowledgement, and memorialization, that those shall all be guiding principles for our work because those are all elements which victims and survivors feel that they need and deserve. So to conclude, those elements shall also guide our work, all of us in various roles involved in supporting those victims. But the very first step is to sit down with victims and to attentively and actively listen to their voice, and then to adapt our actions and our communication with them. I'm going to stop here. I'm looking forward to the discussion.
Thank you very much, dear Adriana, for your remarks and experiences. Actually, as it has been emphasized, as terrible as it is the crime, it's equally terrible the denial of the crime. And the international justice mechanisms, as you emphasized in your speech, have an important role in that regard as well. So to draft the narrative, the true narrative of the crimes, and not only for the sake of the punishment, as it has been raised also by Professor Mzia and Professor Ayla, but also to meet one of the major objectives of the transitional justice, which is to prevent the recurrence of the conflicts and the wars and the crimes. And obviously, if there is a state of denial, the possibility of recurrence is always there. You brought two landmark cases of the International Court of Justice. We all know the Bosnia and Herzegovina versus Serbia genocide case, and also the cases of the ICTY, Ivica Stanišić and Frankis Simatovic. Obviously, the example of Bijeljina, which some of us remember the example very well, I mean, from the time when it happened. Emphasized an important point, which is having a survival-centered approach, not using particularly the victims, but also the witnesses as a material evidence or tool for the court in the court proceedings, but creating systematic conditions for making them psychologically comfortable to pursue the justice or to contribute to the justice. We have the last but not the least panelist, Miss Natalie, with her experience from the UK on the issue of the conflict-related sexual violence. Miss Natalie, the floor is yours.
Thank you very much. Thank you. It's really an honour to be on this panel and to be at the forum, and really huge thank you to the government of Kosovo for gathering us here today, and I think it really speaks to the Kosovan government, Kosovan civil society, and importantly Kosovan survivor leadership on the issue of tackling conflict-related sexual violence, which we're really seeing. As I think many of you in the room know, the UK has been working on responding to and preventing conflict-related sexual violence through our PSVI pretty consistently for a number of years now, since 2012 when the initiative was first launched, and I'm privileged to lead the initiative now, and supporting projects around the world through PSVI, including here in Kosovo, for example, with our work with KRCT. And through that experience, I think, very much despite these kind of enormous global efforts over a number of years, we still see huge challenges in terms of justice and accountability for conflict-related sexual violence, as my fellow panelists have said. Rates of prosecution for sexual violence remain shockingly low. Even when prosecutions occur, it can take a huge amount of time. And as one of my colleagues is fond of saying, this justice delayed is justice denied. And that delay still is something very challenging for victims and survivors. And building on what the previous panelist has said, I think we still too often see that the experience for survivors, victims, and indeed witnesses of going through prosecutions can be re-traumatizing, can be stigmatizing, and can be shaming. So with all of these challenges, the UK through PSVI is continuing to work and to kind of heed the call for action that we've heard today to try and tackle some of these issues. And I'll just kind of pull out a few examples of some of the things that we're working on with our colleagues in civil society and in the international community to try and address some of these. So the first, and building on what the previous panelist has said, is the effort to really take a survivor-centred approach to justice. And I think over the course of the 10 plus years of PSVI, I think this is really a lesson that we've learned and something that we've increasingly come to focus on. Those of you who were in the previous really amazing panel from KRCT on the experiences of male survivors might have seen the intervention from Kolbasia Husu, who's one of our PSVI survivor champions. And so in 2019, we appointed 2 survivor champions to really help us, I suppose, to take not a kind of tokenistic approach to working with survivors, but a really genuine approach for survivors, shaping decision-making and policy-making in an international forum. And I'm really pleased that we've now expanded that to a survivor advisory group, which includes Kosovan survivors. And so taking this kind of really survivor-centered approach, we've tried to implement and develop tools and guidance that can help to ensure this really survivor-centered approach to justice. So to pull out a few examples of those, last year the UK, alongside Nadia Murad, the Nobel Prize winner, launched the Murad Code, which is a set of guidelines to support institutions to take a survivor-centered approach, not only in justice, but very much including in justice and accountability processes. And I'm really pleased that Kosovo was one of 12 countries to endorse those guidelines at the PSVI conference in 2022. And for those who've not looked at them, I do really encourage you. We hope that those are very practical tools for countries seeking to take a survivor-centered approach. And then something we're working on at the moment, building on the points around stigma, is with an organisation called Synergy for Justice. We're working on developing a stigma toolkit to try again and put into place practical steps for every step of the justice chain to try and tackle stigma. So that survivor-centred approach remains, I think, a really big focus. The other area that I wanted to draw out, because I think it's become relevant in a lot of these discussions, is the importance of sharing expertise, sharing experiences across different contexts and different countries. And I think this forum's been a brilliant example of that, and we've heard from organisations instituting new initiatives to share experience. The UK launched last year the International Alliance on the Prevention of Sexual Violence in Conflict, and we hope that's going to be a really useful forum for bringing together different countries, sharing lessons and experiences, and again, very pleased that Kosovo has joined that International Alliance and is actively participating in sharing lessons learned. And the last thing, because I'll keep my remarks very brief, the last thing I wanted to draw out that certainly we're thinking about, and I wanted to maybe open it also as a question for others, is how can we use some of the changes and developments that we're seeing today, particularly technological change, as an opportunity to help us tackle some of the challenges that we see in justice and accountability for conflict-related sexual violence? So I think we're all aware of some of the risks and the challenges that technology has created when it comes to gender-based violence, technology-facilitated gender-based violence. But also I wonder about what are the opportunities. So one area that we're working on is, for example, with the International Criminal Court. The UK launched at the end of last year a virtual reality app and system with the idea that for survivors, victims and witnesses, they can sort of have an experience of what the ICC feels like, looks like, and what their engagement would feel like as part of going as a victim, as a survivor or as a witness. And so the hope is that that will really help to make the experience less stigmatizing for survivors and victims and encourage people to come forward. So, you know, it's clearly a very difficult topic, a number of areas of challenge, but I certainly, in some ways, leave this panel and this discussion with some optimism because of the work that's going on around the room, and above all, because of the courage of survivors and victims who continue to come forward. Thank you.
Thank you very much. Thank you very much, Natalie. I'm being signaled that we have a couple of minutes. Obviously, we have exceeded the time. I'm just briefly, first, thank you very much for your contribution. Actually, I avail myself of this occasion to express our gratitude to the UK for the support to Kosovo on this issue, but other issues as well. You mentioned three important points: the survival-centered approach, the sharing experience, and the use of technologies of today in the issue of the prosecution and the justice, basically, for the conflict-related sexual violence. Now I'm opening up for questions from the audience. I will just have to remind you that we are very tight with the timing. Actually, we have exceeded the time for our panel. I think Ayla wants to take it.
Yeah, if you allow me, I will follow up on what the last panelist said, but also I think like what each of the panelists during this panel said. And following up to your question, like what is the main challenge when it comes to international justice mechanisms? So I think the main challenge is implementation. So we have laws, we have international documents, we have international conventions. They are not the best, but they are not that bad either. And I think the main challenge is implementation. And when it comes to implementation, I think there are two things that are the main challenges here. And the first one is the lack of a survivor-centered approach, and we all talked about it. And the second one is the lack of the recognition of the importance of gender in sexual violence cases. So for me, a survivor-centered approach means doing justice with survivors rather than for them. It means delivering justice to survivors as they perceive it, because we tend to measure success by numbers of trials, numbers of convictions, numbers of years of imprisonment, instead of looking at what survivors need. And to me, survivor-centered approach means effectively consulting survivors in all justice mechanisms. So in their designing, mapping, implementing, monitoring, evaluating. And it means not allowing survivors to feel stigmatized because they are survivors of sexual violence, while their perpetrators are highly respected individuals in their own towns, sometimes even in their own streets, which is a harsh reality for so many victims in Bosnia and Herzegovina. And ultimately, it means not only helping survivors, but also empowering them and supporting them in their transition from being a victim to becoming a survivor. And I think we are not doing a great job here. International justice mechanisms are a bit better than the domestic ones, but we still have a lot of work to do if we want to, for a survivor-centered approach, not only to be like a popular term in policy papers, but genuinely understood and applied. And the second challenge I mentioned is the lack of the recognition of gender in sexual violence cases. And that goes to what the judge was saying at the beginning of this panel. So why is it so important to look at war crimes with gender lenses? I'll try to give a brief example. So in July 1995, Bosnian Serb forces committed genocide in Srebrenica, and more than 8,000 Bosniak men and boys were killed. At the same time, however, more than 25,000 women and children were forcibly transferred out of the Srebrenica enclave. And initially, the ICTY considered only investigating those killings and omitting the forcible transfer of women and children. And this changed only by a coincidence. So in the case of Radislav Krstić, there was a compelling video evidence of his personal role in directing these forcible transfers. And this is why the ICTY decided to look not only to include not only the killing but also the forcible transfer in the Srebrenica case file. And today we know it was by looking at the combined impact on both the killings and the forcible transfer that the picture of genocide was accurately relieved before the ICTY. And this is only one example of why gender lenses are so important in sexual violence cases. And we are not doing a great job here either. So there are still gender biases with the prosecutors and also the judges when it comes to sexual violence cases, in terms that when we have cases with female victims, they tend to focus on the sexual element of the crime, while in the cases involving male victims, they tend to focus on the violent element of the crime. And I think this is not because of the laws, because of the poor laws, or because of the poor international conventions, because almost every single international document emphasizes today the importance of gender in sexual violence cases. So therefore, other factors besides this mere existence of gender equality norms play an important role. And I think that we need to change pre-existing discrimination, subordination, and discrimination. And I think we need to change, we need to work on transforming mindsets. Sorry if I took too much.
Thank you very much. Ayla, we have time for two very quick questions. Yes, sir, the floor is yours.
I think that actually, I'm sorry. I'm sorry. That torture is the legal definition. Rape is torture in the torture convention. The decisions have been made, have been rendered, and that indeed, I think this it just basically rebuts the idea that it is a sexual act, because it is indeed torture. So I guess I'm pretty animated about it, but there is a lot, as you said, Ayla, about gender-based crimes. We need to pay a lot more attention to that, and there's a growing field around torture that is gender-based in explanations and descriptions. I'll leave it there. If anybody wants to comment.
Thank you very much for your question and comment. If anyone from the panelists would like to comment? No, if not, perhaps we'll take another question, if there is a question from the audience. If no, and I don't know whether the panelists would like to say any final remark or not. We are, yes, the other panel is about to start. May I thank the panelists? May I first thank the President of the Constitutional Court for the opening remarks, and the panelists for the important speeches, and also the participants for their participation. Obviously, we can continue our discussion after the panel as well. Thank you very much.